Good evening, good afternoon, good morning. Welcome to Sidat HR Digest, another episode where we bring to you HR issues affecting the profession. You are welcome once again. Unfortunately, last week we couldn't meet due to the internet connectivity, but today is another day where we will delve more into various topics in HR where we can build our profession. So, wondering who Sidat HR Digest is brought to you by Sidat Consult, your number one trusted human resource partner. Sidat Consult is made up of a strong and dynamic human resource management professionals committed to providing innovative, tailored, and practical HR solution and the sustained and excellent service delivery. Our team has a combined years over 20 years HR experience providing HR solution in the area of recruitment and talent acquisition, staff and HR outsourcing, training and development, salary benchmarking, compensation and benefit management, job analysis and evaluation, performance management, and general HR advisory services. Let CDAT Consult partner with you to transform your human resource capability into business growth. Looking at where to find us, you can reach us on 0244 or 0550 You can locate us at Asharman Roundabout off the Michelle Camp Road near the CBG Tema. You can also visit our website www.sedatconsultslimited.com or write to us at info@sedatconsultslimited.com. I also want to use the opportunity to announce to you about our upcoming SEDAT Consult training. We are coming up with a training building a competitive grading system and salary structure. It's a 2-day practical compensation and benefit management workshop for HR professionals, finance professionals, union executive, managers, and CEO. What is the expected outcome of this training is that there's going to be compensation and benefit management tool, grading system and salary structure template. You also have the opportunity to have an after workshop support on the grading system. And trust me, you also have the opportunity to network because you are having seasoned HR professionals coming together. This program, this training will be hosted by our very own Patricia Abnakisi, the CEO of Sedat HR Consult, and it will be facilitated by Kojo Vanes. He's the compensation and benefits specialist and certified trainer. So please don't miss this. It's coming on the 25th to the 26th of April 2024 at the Sedat Conference Room, number 8 Morando Street, behind Qatar International Hostel. So please, you can also see the flyer on the screen. Please take note of this opportunity and build your capacity as an HR professional. So you're welcome once again, wherever you find yourself. Let us know where you are watching us from. You can visit our various social media handles on Facebook, on YouTube, on Instagram, and on LinkedIn. Please connect there and let us know where you are watching us from. Once you just log in, please let us know so that we can acknowledge. We have here with me Michael. Michael Kisi says he's watching us from Cape Coast. Michael, you are welcome. So today is another episode where we are blessed with a seasoned practitioner who is going to walk us through a lot and in detail to safeguard us as employers and also as HR professionals. So today we'll be talking about termination and dismissal of employee. What does the law say? So we must understand that in today's dynamic business landscape, understanding the legal framework governing employee termination and dismissal is crucial for employers and we HR professionals alike. So we are going to look from compliance requirements to safeguarding employee rights and protection, navigating the terrain which requires a comprehensive understanding of the law and its implications. So today we are going to look at delve into the legal framework and requirements, employee rights and protection, best practice for compliance, which is to guide us. So if you just join us today, we are going to discuss termination and dismissal of employees. What does the law says about? And today we are blessed to have a seasoned, well-known practitioner in the HR fraternity. So with that much I take this honor to read about him and to introduce him. Then we know where the discussion is going to be. Trust me, today is going to be an awesome discussion. So just grab your pen and your note, and you will be blessed after this uh, discussion. So we are blessed to have a labor consultant, a mediator, and arbitrator listed with the National Labor Commission. He is a trained non-executive director and a member of the Institute of Directors Ghana. His specialization is in employment relations in mergers acquisition, workplace investigation, and employment law. With over 20 years experience, he spent 3 years in public sector dispute resolution, judicial service deputy director of projects, national ADR coordinator, and 19 years direct human resource management and executive director in the banking and construction sector. He studied mineral processing and metallurgical engineering from Kwame Nkrumah University of Science and Technology. He also read conflict, peace, and security studies at the master's level. He holds a postgraduate qualification in business administration, international human resource, and international relations and diplomacy. He is also an author of two books, The Career Toolkit for Successful Job Hunting and The 51 Rules for a Perfect Gentleman, and also serves several articles on human resource management, dispute resolution, and corporate governance. He is also a certified professional in human resource SPHR USA. At the moment, he is the country director of WBHO Construction Ghana and a multinational civil and mining construction firm. With that much I do or say, it's a pleasure to introduce our very own, well-known in the fraternity, Senyo M. Ajabin. Senyo, you're welcome to Say That Digest.
Thank you. I hope you can hear me.
Hi, Senyo, you're welcome.
Thank you. Good afternoon, everyone. I hope you can hear me.
Okay, you're welcome. I believe you can hear me clearly. I
Yes,
can
I can
clearly
hear you
hear you
clearly as
now.
well.
You're welcome to Sedat
Okay.
HR Digest and brought to you by Sedat HR Consult. And it's a privilege to have you here to discuss such an important topic.
Thank you. Thank you for having me. Okay. So I think we're having connectivity problems from the host. Uh, so I will just take the opportunity to welcome everybody and also start with basically an overview of perhaps the legal framework um, regarding terminations of employment, of contracts of employment in Ghana. So basically, the legal framework for terminating employment in Ghana is actually subject to our 1992 Constitution, Articles 21 of the Constitution, Article 19 of the Constitution, that basically talk about officers, administrative bodies being fair in terminating employment. And then beyond that, the Labor Act, Act 651, passed in 2003, then gives a more detailed framework on how terminations should be done. So basically, we have two different types of termination based on which the law will apply. So there is voluntary terminations and then involuntary terminations. Now, the law basically looks at ending the employment contract, any employment contract at all, as termination. But based on the mode of exiting employment, or based on the mode by which the employment is ended, or the contract is ended, then we can classify them under voluntary or involuntary. So involuntary termination of employment, basically it means that both parties agree that they want to end the contract of employment. Oh, you are back. So do you want to take over? Okay, let me continue. Once you interject, then I know you are. So involuntary termination of employment is no problem because both parties agree, and that is where, for example, employee resigns from employment, and where the employee resigns, because there is no forced labor under our laws. Our laws above forced labor, then nobody can be forced to work. So when somebody resigns, immediately it is accepted and known that the contract of employment is ended. Then both parties can also mutually decide to terminate employment. And here we can find it under grounds for termination under Section 15 of the labor law. So here, Section 15 A would say that a contract of employment may be terminated by mutual agreement between the employer and the worker. So where they both agree, then it's voluntary, and they discuss the terms of the termination, and then it goes on. So there is no problem. But where the problem is the involuntary termination of employment, where we look at the various modes by which people are made to leave involuntarily. But before I go on, remember that there's also retirement. Retirement is also a voluntary termination. Well, I see it as it being on the borderline because it is law that when you are 60, your employment will be terminated on a permanent basis. So whether involuntary or voluntary, we need to know that by that time we are going. So yeah, we can place it under voluntary or involuntary depending on how we look at it. But when you come to involuntary termination, this is where the employer often terminates the employment on the basis of certain reasoning, like performance, like misconduct, and also like redundancy. So where the job is no longer available, then the contract is involuntarily terminated. And so this would be generally the legal framework. And where the contract is to be terminated, whether voluntarily or involuntarily, then we have specific procedures that we follow. And these procedures are normally found either in the contract of employment or collective agreements between a union and the employer, or the labor law, as the case may be. And remember that these procedures have specific things that should be done when the contract is to be terminated or where the employee is exiting. And this we can see in Section 18 of the Labor Act. So in Section 18 of the Labor Act, employees are supposed to be given notice. They are supposed to be paid their exit remuneration, they are supposed to go through certain handing over processes and all that. So where an employee is to be terminated under Section 15, which is the specific grounds for termination, they have to be paid any remuneration earned before termination, any deferred pay, any compensation due them, and the employer shall ensure that termination remuneration or exit remuneration is paid on or before the exit of the employee. Legal framework ongoing, and I'll wrap that one up just in a bit. Where the termination is seen as unfair or it is challenged, then the employee has the right to file a complaint either with the labor courts or the National Labor Commission, and then a hearing is done and then the matter is resolved. So basically that is, and this complaints or reliefs of the complaints can be seen in Section 64 of the Labor Law. So this is generally an overview of what termination or the legal framework of termination of employment. I realized that Eben is still not around. So let me look at another question that he was going to ask me. What are the key legal requirements that employers must adhere to when terminating employment? Basically, the legal requirements has to do with two basic things under a broad principle of the principles of natural justice. So the legal requirements under the principles of principles of natural justice would be that there has to be justification for the termination, and then the termination must be done in accordance with a lawful procedure. So there has to be procedural fairness, and then there has to be a substantive justification. Now, I am sure a lot of people would want to know once and for all, and that is why people may be interested in this particular presentation as to is it enough to just give notice and terminate? So I first talked about the procedure for termination. There has to be a decision to terminate, and then a procedure is gone through for termination. And one of those procedures is notice. So the procedure for termination, especially where it is not dismissal or it is not for gross misconduct, is to give notice or pay the employee, in lieu of giving them the required notice. So notice is a procedure, is an exit procedure and not a ground for termination. Let me repeat that. Notice is an exit procedure. It is part of the exit procedures, like paying the person before the person leaves, handover processes and all that. But notice is not a ground for termination. So the grounds for termination, which is found in Section 15 of the law, I've mentioned the mutual, which is voluntary. Then there is the involuntary ones where the worker may terminate on the basis of being ill-treated or sexually harassed, or that the employer would terminate the employment on the death of the worker, that the employer may terminate if it is found that the employee is medically unfit to continue working, and then the employer may terminate also for the employee who is unable to continue doing the work they've been required to do due to sickness or accident or incompetence of the worker or proven misconduct. So these are the grounds on which under Ghana law employment can be terminated. So if the law gives grounds on which employment can be terminated, then it is not adequate for anyone to say, I will give you notice and terminate, whether that is stated in the contract of employment or not, especially where it is challenged. And let me just take you to section 63 of the law, 63(4), which says that a termination may be unfair if the employer fails to prove that A, the reason for the termination is fair, or B, the termination was made in accordance with a fair procedural fairness, or the provisions of the law. So it means that it may not just be enough for an employer to show up before an arbitrator, a mediator, a judge, or the commissioners of the Labor Commission to say that I gave him notice, so it is enough under our laws to terminate his employment. And that is something that we should be clear about. Where challenged, an employer would have to prove that he terminated on specific grounds, justify the grounds for termination, and also prove that the termination was made in accordance with a lawful procedure or the Labor Act. And a lawful procedure means that that procedure must have been told, taught, or explained to the employee prior to the termination action. So the employee needs to be aware of whatever procedure is available. What documentation is typically required to support a lawful termination? So basically, there would be about three primary documents required to terminate employment. The first one would be the contract of employment. So the contract of employment is important. That will tell the nature of the contract, the status of the contract, or the status of the employee, and all other things, provisions, as agreed between the parties. So the contract of employment is important. The policy of the employee, of the employer, the policy of the organization. So it could be the disciplinary policy, or any policy that has to do with exiting employees. So the termination policy or employee exit policy, there has to be a policy. Remember that Section 8B of the Labor Act requires that the employer is supposed to develop policies. Yes, so 8B, employer is supposed to formulate policies to regulate the employment relationship. So if there is no such policy, then the employer is seen to have slept on their rights. And this is where the HR people become very important within the framework of organizing or terminating employment or having to exit employees. So that's the second one. And then the third one is the Labor Act and the various, the LI 1833, the Labor Regulations of 2007, LI 1833. So these are the main documents. If there's a union, you would need to have a collective agreement, and the provisions of the collective agreement are going to tell exactly what should happen when an employee is to exit. Now, the question then would be, which of these documents hold precedent? Okay, which of these documents hold sway over the other? Which one is the most important? The first primary document of reference, often in any adjudication process regarding the exit of employees, would be the contract of employment. Okay, the contract of employment. And where there's a union, it will be the collective agreement. Now, if there is a union and a collective agreement is in place, then the primary documentation will be collective agreement, because according to Section 105, where the contract of employment and the collective agreement are put side by side, that is when they go against each other, the law says that the collective agreement would hold sway. And in subsequent, maybe industrial relations sessions, we can explain why the collective agreement holds sway, because the employee would have submitted themselves to the constitution of the union, and therefore it is the collective agreement that would be the applicable document to regulate the termination of employment where there is a union. I see that Eben is back. Eben, do you want to continue?
Okay, thank you very much. The internet situation, it keeps uh, bringing me up and down, but thank you so much for holding the fort. And I believe so much our viewers have learned a lot. So we'll still delve much into it, and we'll look into it. I believe you talked about the legal framework, talking about the CA and the contracts. That's where I interjected. So if you can end with that, then I take my questions from there. So you can
Yeah,
go
so
ahead
generally,
and
I think I have dealt with the the first three. So I ended on the various documents that are required um, for the lawful termination of employment. So we can take it on from there. Maybe the fourth question, or if you want to skip to the other questions, um, it is your show.
okay, thank you very much. So if you just joined us, you just joined SIDAT HR Digest brought to you by SIDAT Consult. Today we are having a discussion on termination and dismissal of employee. What does the law say? So we are looking at the legal framework and requirements around it, employee rights and protection, best practice for compliance. And this is, we are blessed to have Senior Ajabin facilitating this session with us. So he talked about a lot. So we'll delve right into employee rights and protection. So I think most of the times when it comes to termination, employers always have the upper hand looking at situation because employees are not well informed about situation. So we'll delve into employee rights and protection. So, Senor, what rights do employees have when facing termination or dismissal?
So employee rights basically is, I think I can name two from the top of my head. First one is that they have the right to um, a fair procedure. So they have a right to go through a fair procedure, and then they have a right to defend themselves if they are accused of anything. So if the exit entails any accusation, then they have a right to be heard under the principles of natural justice, uh, which we say audi atra partem rule. So under audi atra partem, employees it means hear the other side. Okay. So they need to have the right to be heard. And that right to be heard means the right to defend themselves, the right to be represented by anyone of their choice. Let me say it again, the right to representation by any one of themselves. So those employer policies, disciplinary policies that says that you cannot bring in a third party legal person, you cannot bring a third party a consultant, you can only bring a colleague, then that is a breach of the employee's right to be heard, because the employee needs to have all the resources available to him to be able to defend himself or herself where they have been attacked or where they have been um, accused of anything. And mind you, it is a matter of the loss of financial security, and it's an adverse occurrence on the employee within the employment agreement, and therefore they need to be given the right to be heard if they are accused. If termination is voluntary, that is fine. But where they are accused, they need to have the right to be heard. Yeah. Eben? So there's another question that has to do with how can employers ensure that employee rights are protected throughout the termination process. Basically, by having a policy and following those policies, and following those policies without distinction or without bias. So it has to be a policy that applies to everyone equally. Now, these policies, the disciplinary policy will say that where an employee is to be terminated, they have to be taken through the disciplinary process, which starts with the progressive discipline, warnings, and after the warnings, after final warning, they may be terminated. And in all of these, there has to be a disciplinary hearing where, in a civil fashion and a summary manner, the disciplinary committee will hear the issues against the employee and get a response of the employee, and on a balance of probabilities decide whether the employee is culpable of what they have been accused of or not, and pass a recommendation to management as to what applicable I don't want to use the word punishment, penalties, what applicable penalties should apply to the employee. And so basically, this would be one of the ways that an employer would ensure that the rights of the employee is protected. Mind you, the employees are protected to the extent that where, for example, let me take you to section 63 C. A worker's employment is terminated unfairly if the only reason for the termination is C, that the worker has filed a complaint or participated in proceedings against the employer involving alleged violations of this act or any other enactment. So the employees are so protected by the law that where they have even made certain complaints or been involved in proceedings against the employer can still not terminate. So while the employer is supposed to have a policy that regulates the termination of employment, and also the discipline of the workers, the employer has to go through the various procedures that are applicable in that workplace. Okay, so they need to follow their own policy and the provisions of either the contracts of employment or the collective agreement, as the case may be. And then beyond that, they cannot terminate an employee where the employee has even been involved in certain processes and proceedings against the employer. So in essence, the employees are extremely protected when it comes to this. As to whether the employee normally would get justice where they've been unfairly or wrongfully or unlawfully terminated, that is another discussion, because sometimes even though justice is often served, it delays so much that the ramifications become quite unbearable for the employee. In the case of wrongful termination, what recourse do employees have under the law? That is one of the questions I was also supposed to be posed. Basically, the recourse is to try and dialogue. That's the first one. So try and dialogue, bring the issues before the employer and try to get the employer to understand, to negotiate a deal outside of the termination process, or even if termination is agreed, the conditions and terms of the termination, such as compensation and all other benefits. But where the dialogue fails, then the employee has no other remedy except to go to a third party adjudication body, um, which would be the labor court, as I've mentioned, the labor court or the National Labor Commission. And the National Labor Commission may hear the matter summarily if the employee so wishes, or would refer the matter with the consent of both parties, the employer and the employee, push the matter to either mediation or arbitration, which end game becomes a binding settlement on, or an award on the parties, and then the matter gets resolved. So those would be the legal remedies, or recourse that would be available to an employee to who believes that the employment has been unfairly terminated. Going on, we'll come to the questions. So please keep your questions coming. Um, I'm sure that within the next less than 10 minutes, we can go on to your questions. So, what are some best practices that employers should follow to ensure compliance with legal requirements when terminating an employee? My comment on that would be employers must be very slow to terminate employment. I'm not saying that they cannot terminate employment, but there are a lot of boxes that need to be ticked before they terminate employment. Reason being that when you terminate the employee, either verbally or in writing, the immediate impact is that the person has become an ex-employee. So the person is no longer an employee and cannot take advantage of your internal processes, such as some policies I've seen would say that the employee should petition. Employee can only petition as an employee using the internal process. But as soon as you terminate, you hand over that termination letter, you immediately make it difficult for the employee to use any other internal process other than external processes like bringing in an external consultant, filing the matter with the courts or the labor commission, or basically taking the matter to Shraj or any other place. So the first is that an employer should not be in a hurry to terminate. The other thing is that where an employment is to be terminated, let's first see if we can get and convince the employee to resign. If we get the employee to resign, then it comes under the voluntary process where we get what we want. We want the employee out, and the employee then goes out. Where it is not an action from the employee, or the what is causing the need for employment is not based on, say, incompetence or gross misconduct. Okay. For any other reason, we need to see whether we can come to an agreement and voluntarily terminate the employment. Beyond that, if it is going to be involuntary, then we need to ensure that we follow the procedures under our policy or under the contract of employment. If it is an accusation, we need to ensure that we give the employee an opportunity to be heard in a disciplinary process, and be sure that we have followed all the disciplinary processes, gotten the recommendation, ensured that the employee has been properly heard, and that we are justified and have the necessary evidence of breach or any other evidence that will cause us the right to be able to terminate under the contract of employment. Anything short of this would mean that where we are challenged, we do not, if we are terminating an employee, we do not owe anything to the employee to justify to the employee or whatever. But when we are challenged and we go before a court or the National Labour Commission, we would have to justify how and why we terminated employment. And that is where a lot of employers are found wanting. Then, can you discuss the importance of clear communication and documentation in the termination process? I think this one, I have gone through it. How should employers handle termination involving sensitive or contentious situations, such as performance issues or misconduct allegations? I think the involuntary, I've talked a lot about it. Let's talk about performance. Performance is a contractual matter. Our contract of employment is based on performance, that will pay you X if you do Y. So where you are not doing the Y, you are not playing your part, then it gives the employer the right to terminate the contract of employment for breach. And therefore, what is necessary in performance-related terminations is that there has to be proof that there has been continuous non-performance and that the employee has been assisted to perform better, such as in a performance improvement program, a PIP, or a training program, or continuous training, coaching, mentoring. There has to be proof that there's continuous non-employment, efforts have been made to help the employee to perform better, and none of that has changed anything. The employee continues to non-perform. Under those circumstances, the non-performance becomes a contractual breach, which should go before a disciplinary committee or which should go before a performance review board that would give the employee an opportunity to explain why they are non-performing even after all the additional resources of assistance have been given to them. And based on that report, non-performance review report, the employment can be terminated. This would be, for me, the appropriate means by which contracts can be terminated using non-performance, because it is a pure contractual matter. It is not a disciplinary matter, and it is not also an ad hoc termination matter. There has to be proof. And that is why the law under Section 15, Section 15E, II, it says the incompetence of the worker. If you go to Section 62, which is fair termination, the 62B would say that the proven that the worker is incompetent or lacks the qualification in relation to the work for which the worker is employed. So it has to be proven. Incompetence has to be proven. And we cannot just say an employee has non-performed and so they should be terminated. There has to be proof that they've non-performed. There has to be proof that they've been assisted to perform. And where they are still not performing, there has to be a formal hearing, a review, either a disciplinary committee or a performance review board that would grant the employee a hearing to explain why they are not performing. And after that, a report recommending termination can then be upheld by management. Okay. Let me tackle her last one, and then we can go into the questions, I think. What role does HR play in ensuring that termination procedures are conducted fairly and in accordance with the law? So basically, all exit processes hang on the HR people. They are to ensure that, one, there is a contract of employment. And in that contract of employment, the terms of termination are properly stated. It is not enough, as I've said, for a contract of employment to just say that I'll give you notice. Each party will give either party notice of 1 month or pay in lieu of notice. That is a termination procedure. That's an exit procedure. There has to be grounds for termination in the contract of employment, in the collective agreement, or any other policy that is developed by the company. And it is the HR people who should ensure that these documents are there. In the exit process itself, the HR person must be the watchdog, must be the last door for checking and ensuring that there's justification for termination and an appropriate lawful procedure has been followed based on which termination has occurred. And where these do not happen, then it is the fault of the HR person. So if those termination decisions are imposed on an HR person, that HR person must ensure that there's documentation to show that they sought to do the right thing, they sought to have the processes followed, they recommended, the right procedure to management, but management decided to ignore. That is the only way an HR person can absolve themselves from culpability where a termination goes wrong. In my sphere of practice, where termination processes go wrong, and it is clear that the company didn't do the right thing, the first person to hold responsible is the HR person. If the HR people start losing their jobs, okay, so the HR person and the CEOs or MDs, the business leaders, if they start losing their jobs because of such decisions, then I'm sure that we can have a cleaner, a more sanctified process of and dignified process of exiting employees. And like I said, if we have the tradition or the culture of trying to use dialogue first to resolve termination issues, where that fails, we give an employee an opportunity to resign. If that does not work, then a formal disciplinary process is followed based on which termination is done. I don't think we will ever get in trouble with the law for termination. Often terminations that get in trouble are ad hoc. They just follow the wrongful notion that an employee can resign and go, or an employer can also terminate with notice. So once I've given you notice, it is enough. For the reason of time, maybe somebody will ask, there are so many legal, let me say, case law, okay, rulings from the courts that show that an employer will have to justify termination when before a formal adjudication body like a court or the National Labour Commission. It is just not enough to appear before the Supreme Court and say that I gave notice and therefore it is enough. I don't have any further explanation to the court as to my justification for terminating the employee who is challenging the termination agreement. Okay, or challenging the termination action. Right. So let me go to some of your questions.
Hello, Senor.
Yes.
Good afternoon. Thank you so much for holding the fort. I'm so grateful. You are doing great. Thank you so much. Okay, so I see a lot of questions. So let me read some of them, and then we can. I don't know whether you've answered this question.
What happens? Okay, there's a question. Is it still required of the company to serve them termination letter? Yes. Termination is a formal process. When we were employing, we employed with a contract of employment. And
Yeah.
any form of amendment or variation of the contract of employment, including the termination of it, has to be in writing. Okay, so the formal communication of a termination decision has to be in writing. Okay.
Right. Pamela, okay. Pamela says, what happens in cases of mental health with respect to termination?
Well, that would come under the ground of ill health. Okay, so the employee is unable to continue their job, the work for which they've been employed, and to uphold their part of the contract of employment because they are unwell. And on that basis, there should be a policy for exiting employees on the basis of ill health. And that policy normally would come with some form of support and compensation, medical compensation to the employee upon the termination of employment. Yeah. And that also has to be in writing. Yeah.
So everything is in writing. You have to make sure that you leave an audit trail. And I think, Senior, when you are challenged, it becomes very, very necessary for you to prove beyond every reasonable doubt that the termination was actually fair. Elizabeth is asking, must every disciplinary procedure include a disciplinary committee?
Yes. Now I'll tell you why. In the workplace, which the law calls enterprise, at the enterprise level, the Constitution of the Republic sees an adjudication body or the judicial representation of the state at the enterprise level as the disciplinary committee. So the disciplinary committee is a very powerful committee. It has constitutional rights. Its mandate is constitutional as a civil adjudication body at the enterprise level. And that is why often courts would hardly go into the details of a disciplinary. Let me put it this way: courts would not easily interfere with the decisions of the disciplinary committee unless they go into it to find that the hearing breached certain principles, for example, like natural justice, or bias or something. But otherwise, the courts would not interfere with the disciplinary committee ruling to say, or recommendation to say, that an employee should be terminated. There are so many case law to prove this. So yes, every disciplinary procedure must have a disciplinary committee in place, because that would be the mandate, the judicial mandate for deciding the fate of a person who has been accused under the disciplinary procedure. So yes, but it is not all cases or all issues that go before the disciplinary committee. For example, where an employee is queried and the employee accepts that they did something wrong, if they accept culpability, then immediately the schedule of offense applies. And therefore, and in the same way, when you go to court and you plead guilty, then it goes to sentencing. They don't really go to, except in certain exceptional cases, they would normally go to sentencing once you plead guilty. But where you plead not guilty, then they go into the full hearing. So the judicial process in the company mimics, the normal civil summary hearing processes. And these are important because where you are challenged, these things will come to save you. And taking proper records of transcripts of how disciplinary committees went. I did an arbitration where I asked for, let me say, I subpoenaed the video, the recordings of the disciplinary process. And I took time to watch everything myself, where I had to decide whether indeed the process met the principles of natural justice and the employee was actually given a proper hearing. Okay, so yes, it's very important to have a disciplinary committee in disciplinary processes, yes.
Thank you very much. There are lots of questions, so I'm just running them through. So, and this one, they have meant you, pa. Okay. So, Patience is asking, is it lawful for an employer to terminate an employee without any reason? Without any reason?
Yes, it is lawful. It is lawful, yes. It is lawful for an employer to terminate an employee without any reason. It's lawful because the employer does not owe the employee any explanation to end the contract of employment. Assuming that an employer finds that an employee is a threat is a threat to the organization, okay, they have the right to immediately remove the employee from the premises of the employment or the employment place or the organization, and terminate employment on that basis, you know, knowing that if they are challenged, they can justify why they did that. So to give reason to the employee is not the issue, but to terminate on grounds for which can be justified before the lawful bodies, the adjudication bodies, that is where the issue is. I mean, if we don't give reason to the employee, it doesn't matter, nothing matters. But it does not mean that when you go before the Labor Commission or a court and they ask you, on what ground did you terminate? Then you say, oh, well, I didn't have to give the employee any reason. No, they are not asking you that. They are asking what ground you stood on and how can you justify the termination at law. And that is where a lot of, people, organizations get found wanting, because they think that they can just act anyhow and get away with it. But where you are challenged, you have to justify. And like I've said, just giving notice is not justification for termination under our laws. So you would have to terminate on lawful grounds, going through the right procedures, and finally terminating on the basis of natural justice. Okay.
Thank you very much. Enoch Ofori is asking, can you please explain the whole section of 30 of this one? They have to consult senior for proper explanation. Okay. Of 651, how do we justify the accrual principle vis-a-vis section 33, where the employee loses the employer's contribution of provident fund? I don't know whether you get the question clear. I'm really
Yes,
struggling
yes.
to understand.
Basically, 33 is about leave, right? And pay leave commutal to cash. Okay. So where the employee has outstanding leave, then it is commuted to cash and paid to the employee. Now,
Yeah.
for me, it is normal, and it is straightforward. Remember, there's a case of Ada versus ECG, okay, where ECG upheld section 33 to say that yes, under normal circumstances where employee is exiting, their outstanding leave must be commuted to cash. Question is, what constitutes outstanding leave and how are the days determined? It also said, that ruling said that if the employee is entitled to the days where the days are clearly stated, where the days are clear, let me put it that way, then it is commuted to cash based on the basic pay of the employee, and it is paid. Where the employee loses the employer's contribution of provident fund, and this is admitted or it is proven in an adjudication process, like a disciplinary committee process, it means that the employee owes the company, and it will be treated as liability under civil law. So it means the employee has liability, and when there's exit payment, like I read section 18, it's saying that the liabilities of the employer or the employee can be set against the earnings. So I think it should be clear that where the employee is liable and owes certain monies to the company, they can use their earnings and their entitlements to offset these, and it is normal and natural practice. Okay, it's common practice.
Right. Thank you very much. If a company is facing financial challenges and not able to pay workers, due to that, some workers have stopped coming to work without any letter from the worker. Okay, continuation of something. If is it clear,
I
senior?
think I get it. That the
Okay.
company is going through financial um, issues, and then they are unable to pay employees, and then employees stop coming.
Decided
Now,
to.
the employees, yes, they stop coming to work. The, until the employees are formally terminated, they are seen as being in employment.
Yeah.
So the employer will owe them. The employer will continue to owe them until it is settled within civil law. So once they stop coming to work, it doesn't mean that the contract is terminated, because the employer or one of them has to take the decision in writing to terminate and go through the necessary exit processes. But when they just stop coming to work because they are not being paid, it does not necessarily mean that they've been terminated. Maybe if it goes on beyond reasonable time, then it can be seen as, naturally the contract is no longer effective, and then they can then discuss the exit conditions for finally ending the employment relationship. But just staying
But
at
in
home and not
this
coming to
case,
work
what
doesn't.
what what should the employer do? What should the employer do in a situation like this?
Well, the employer can declare a redundancy and negotiate terms on the basis of they don't have any cash. And wherever
Mm.
the employees go, they will show employer can show that they just do not have any cash. And where you take on a man of straw, you don't get any results because the person
That's
doesn't
true.
have anything to give you. Exactly.
Yeah.
And that is why we should be careful the companies we work for. If you go and
Mm.
work for a company that does not really have the financial muscle to follow up on the or to comply with the contract of employment they've signed with you by paying you all the time, paying you on time, and all of those things. You have the option to be able to resign and go somewhere, but where you insist and stay, and you are not paid for 15 months, and now you take it to court that the person owes you. If they go and show that they don't have the money to pay, everybody loses. So yeah, I think I think that is
God help us. All right. Amma is asking, what does an employee do when he or she has been terminated 1 month into starting a new job and the reason stated is non-performance? Meanwhile, the employee has not been called or evaluated at all.
well. Probationary termination is a very interesting one. We
Yes,
should
it
all know
is.
that we should all know that probation is a trial period for both parties, and there is no law that stops an employer from terminating employment within the probationary period. In fact, she's even lucky that they gave her a reason that non-performance, because the employer can decide that no, I no longer wish to continue with the employment relationship and I'm terminating without any explanation, and it will still be lawful because it's a trial period, and each
Yeah.
party is able to opt out of the relationship at the probation stage, unless, of course, there are express provisions in the contract regarding probationary termination. But if there's nothing, then it's open to both parties. So probation is key. If you are terminated during probation time is for fasting and doing the right thing in the employment and doing your best, because once you are terminated, it is a done deal. The employer has the right. It is only when you are confirmed and you become properly so employed, confirmed employee, then all the things we are talking about, your rights under the law, they apply. But those do not apply when you are in probation. That one, everybody should know. So I always tell my female friends, we should try and make sure that we remain as we went into employment. And wait, when we get our confirmation letter, then we can do anything else, because they don't have to give any explanation for asking you out of the company or terminating your employment, and it could be for any reason or no reason, and they will be right. So if you, for example, you are pregnant and during or after probation, they say they are not continuing with the employment, unless you can prove that it is because of your pregnancy. Pregnancy is not an illness. Pregnancy is a natural cause of a woman's health. And so in probation, they can say that, oh, we just, no, it's not for pregnancy, but we just didn't think that we want to continue with the employment. It makes it messy, it makes it very complicated. So probationary termination, very sensitive. An employer has the right to terminate at any time for whatever reason or for no reason during probation. Yeah.
Wow. All right. Ophelia says, how can, I think this is last question or last button, how can all this be packaged for the appreciation of employers within the MSME, the medium, micro and small, medium-sized companies who feel adhering to these processes is the preserve of large entities? Do you get the question?
Well,
So,
yes. Yes, the posture of the SMEs, that is small to medium enterprises in Ghana, who are normally headed by indigenes, Ghanaian entrepreneurs, have a posture like the labor law does not apply to them fully, and they cannot be taken on. Those ones have not really faced the rigors of the law. They've not really been made to explain because they hide behind lawyers and law chambers, like attorneys. They hide behind these attorneys who protect them, and they drag the issues to the detriment of the employee. But of course, it goes a long way to taint their image, because often industrial relations and human rights is one of the key reasons for obtaining loans or for being given loans, especially by international agencies, export, the Exim Bank, and those things. So it goes a long way to affect them. So they can continue breaching those things until one day they are properly taken on, and they know that to grow, they will need to have these policies in place, and they'll have to have a clean record. Yeah.
before that happens, they need to consult you so that you can open their eyes to the realities. Because, like you
Yes,
say,
yes, yes. For a very
you might
small
think
fee.
there is no law until you fall foul to the law. Then you realize that indeed there is a law. Okay, thank you. Vina says,
Yeah.
in the case of
Yeah.
transferring of a staff, how many months of notice should be given, and what sections of the law support that? Say.
Okay. So notice is in section 17 of the law. Okay. So for a contract of more than 3 years or 3 years or more, it is 1 month. A contract of less than 3 years is 2 weeks. And a contract from day to day is 24 hours. So it gives the range. For higher executive positions, normally notice of termination becomes a bit more, like 3 months. And it becomes practice because you cannot expect a CEO to hand over in 1 month.
Yeah.
It's too short a time and may affect the fortunes of the organization. So for executive positions, normally it is more, like, but section 17 will tell you exactly how many months or the duration of notice of termination. Yeah.
But that's why he's talking about transfer. I don't know whether you mentioned staff transfer in your.
No, in the case of transferring a staff, how many months of notice should be reasonable? Notice.
Yeah.
Reasonable notice. If it's a permanent transfer, then notice of a month may even be a bit too short. But for modern organizations that, like a bank, that need to move their people around quickly, then I think 3 weeks to a month is fair, or a month and a half is fair. It's fair for people to move. And when they move, they need to be given all the assistance to settle very quickly. So yeah, a month and a half should be fair. Yeah.
Okay, please, last question so that we can release Senor, because it's far beyond. There are a lot of questions, but we'll compile them, share with Senor, and then we can get back to you, please, if I'm not able to read your question, because yeah, we past time. So Emmanuel Duncan is asking, in the process whereby the company doesn't have policies and procedures concerning termination or dismissal, like a typical startup company, what's the best practice the company can engage in? So have policies. Okay, send over to you. I don't know whether
Well,
I get.
I get it. Why should for a startup, um, once the company employs up to 5 people, they should have policies in place. Okay. You don't need a bulky policy like everybody else, but you
Yeah.
should have the basic policies. A talent acquisition policy that deals right through recruitment, selection, up to probation, orientation, and confirmation of employment. That can be one policy. You can have your exit policy, back it with a disciplinary policy that has to do with conduct and all that. And those would be some of the basic policies you can have. We are not saying you should have a huge document with all of those policies inside, but basic policies that make life easy and anybody able to run the employment relationship properly within the organization. 3, 4, at most 5 policies would do the key ones. So let's try and get these policies in place. I mean, it will cost you averagely about 1,500 to put one policy in place. If you are very small and you negotiate well, you can have those 5 policies for the price of that 1,500 or maybe 3,000 cedis. So these things, if you can't employ um, someone, you can't employ a quality HR person who can put these things in place, you can always get a consultant on retainer for 6 months, pay the
Yeah.
person some amount of money per month, and then they'll put all these things in place for you within the 6 months. And you can bring in an HR officer who will come and follow through with whatever the consultant puts in place. Yeah.
Yes, yes. Thank you so much. And my last question before we go, Love is asking she's saying in a CA, if you do not come to work for 10 consecutive days without permission, your employment is terminated. Should you go through the process or just rather to terminate?
Okay, so if you have a vacation of post policy, that typically is a vacation of post policy.
Yeah.
The vacation of post policy is straightforward. You don't need to go through a disciplinary process. If you've abandoned the job, then it means that by your action, you have voluntarily terminated the employment. So a typical termination letter on the basis of vacation of post would be to confirm the termination of employment, because the employee would have, by their action, already terminated the employment. If you are supposed to show up to work under your contract of employment, you don't show up day 1, day 2, day 3, day 4, day 5, up to day 10 without any explanation or authorization, okay, or permission from the employer, it means by your actions you are no longer interested in the job. And the employer will only write to you to say that, yes, we confirm your termination of employment. And that basically is vacation of post. So no disciplinary process in this kind of termination. Yeah.
Thank you very much, Senor. And if you need a consultant to put together the policies for you, Senor is your best bet. So you can reach out to me or to Sedat Consult, who would connect you with Senor. Or Senor, if you don't mind, I want to put your number out for them to reach you, please do. So that those who, because policies are very, very important. It guides the employment relationship. with that you open yourself to so many things. So Senya, maybe before you go, you can put your number out. I know your number is a public number. Everybody calls you, so that they can reach out to
Yes.
you, and then you
I've
can
actually put it on the comment thing. Yes. So it's
okay.
0244792728. 0244792728. It comes to WhatsApp. There's no limitation as to what time you can text me or call. If I'm able to pick your call, I'll pick it. If I don't, I'll call you back. Just get in touch, and don't be shy or afraid. Just get in touch, and we can help you out with anything you need.
So your people are asking for part two. So we will think about it and, and bring
Okay,
you back
okay,
to continue with the
okay. That's
conversation
fine.
on termination and dismissal. Thank you so much for always making yourself available. I know how passionate you are about the employment law and sharing and helping organizations so that we are not put in hot waters. Thank you for availing yourself. I'm very, very grateful. And thank you everyone for joining us. And my apologies for Abel not being able to be with you throughout. But Senor, thank you so much for holding the fort so beautifully for us. We are grateful.
Thank you,
God bless
everyone.
us
Thank
all.
you, and thank you to Sedat Consult.
Thank you, Senor. I was going to ask you to give your final word. I don't know if that is your final word.
Oh, well, let me just say that termination, exiting, and all these contractual issues are quite technical. It takes a lot to know exactly what to do. So we should just consult. We should just find out, call a friend who you are sure belongs to a company that is doing the right thing. Talk to some of us. I mean, I wouldn't charge you for just responding to whether you've done something. Bounce your issues off us and let us confirm it for you and guide you. I mean, that does not come at a fee, because if you don't and you make mistakes and you have resources within the system, we are all in this country. We want the best for every organization. And so let us keep talking, let us keep engaging, and I'm sure we can do the right thing. And I'm looking forward to the part two, if
Yes, we are
really I'll
also
be given
looking
the
forward to it.
opportunity to come in.
Yes. Very
Thank
soon
you.
we'll bring you
Thank you.
back because thank you so much. And thank you everyone. Please, a reminder, our upcoming training on compensation and benefits management is coming up on the 25th and the 26th of April at the Sadat Conference room at the 8 Morindo Street behind the Qatar International Hostel. You won't miss it. Please watch out for our flyer, and the link has been posted in the comment section. Click on it, learn more about it, and register. You won't regret it. Thank you, everyone. Thank you, Senor. And may we have a great week ahead of us. God bless us all. Bye, everyone.
Bye.
Bye.